Good afternoon, everyone. My name is Cassie Hopkins, and I help coordinate the webinars and events for Hausman Johnson Insurance and the Benefit Services Group. Thank you guys so much for joining us today. I would like to welcome you to today's webinar, American Rescue Plan Act, ARPA, COBRA Premium, Subsidies, and Other Topics. This webinar is interactive and will feature a question and answer session. Sarah has asked that you keep all of your questions until the very end of the presentation, so please wait to type in your questions until the question and answer session. After the webinar is over, there will be a short survey we're hoping you can fill out for us to give us some feedback on the webinar, as well as webinar topics you are interested in learning more about. This webinar is recorded and will be available on the webinar archive version of our website. Each attendee will also receive a follow-up email with a link to the recording and the presentation slides. It is now my great pleasure to introduce to you our speaker, Sarah Borders. Sarah has spent the last 15 years in the employee benefits industry and has numerous designations and serves on the NAHU's Employer Working Group Subcommittee and is an active board member of Austin AHU. She recently stepped down as the Vice President of Benefits Compliance at one of the nation's largest brokerage firms, and she did it to start her own compliance consulting practice. Her designations include an active license with the Texas Department of Insurance, CEBS, Certified Healthcare Reform Professional, HIPAA certification, and Healthcare Service Associate. She holds an MBA from Texas A&M Corpus Christi and a BA from the University of Incarnate Word. Her consulting firm, Benefits Compliance Solutions, partners with employers to identify unknown risks and avoid hundreds of thousands of dollars in fines and lawsuits from failure to comply with their health plan obligations. Thank you so much and welcome, Sarah.
Thank you so much, Cassie, and thank you all for joining today's presentation. I think we have a great group today, and I look forward to helping you to try to understand the recent ARPA legislation as it relates to COBRA subsidies. So today, as Cassie mentioned, if possible, please hold your questions till the very end of the presentation. I want to make sure that we get through all of the content, and I think that most of your questions that you might be wondering about will be answered in subsequent slides. I'm going to give a lot of examples and give you some information that you can take with you today, formulate a plan of action, and BS3 Hausman Johnson will be there every step of the way to assist you with complying under ARPA, as well as the outbreak period rules, which I'm going to talk about as well. So today, as I mentioned, we're going to talk first about the COBRA premium subsidies under the American Rescue Plan Act. And we'll talk about what it kind of means, who it applies to, which plans it applies to, which employers it applies to, the notices that you're going to have to be sending out or your COBRA vendors will have to send out, the tax credit that applies for being paid back the subsidy, because you will have to pay the subsidy, but the federal government will be paying you back in the form of Medicare payroll tax credits. Also, we're going to switch over to dependent care FSA changes that were tucked into the ARPA legislation, and we're also going to talk a little bit deeper today about the COBRA outbreak period rules. So if you were on our last webinar together, which was about a month ago, we talked briefly about the outbreak period rules, but today I want to go through about 6 or 7 different examples so that you really understand how this works and kind of how it's going to interact with the ARPA law. So let's get started. So under the American Rescue Plan Act, there is a section called Preserving Health Benefits for Workers. And you can see right away from the title of this piece that it really speaks to making sure that workers are covered, that they have some sort of health insurance in place, and it isn't exactly as directed to the employer. It's more friendly to the employee or the former employee. So this will provide COBRA premium subsidies, including state continuation for small employers, 100% paid by the employer, tax-free to the individual. It'll be available to assistance-eligible individuals running between April 1st, 2021 and September 30th of 2021. So the 6-month period over the summer that we're approaching. We're actually in it now because today is April the 8th. It will allow a plan enrollment option, and the federal government will pay the subsidies through credits against the employer's Medicare taxes. There are several new notice requirements for plan administrators, and we're going to go through all of this today in a lot of detail. So you should be very well versed in ARPA after we're done today. So the main question is to identify who are the folks that are actually eligible for the subsidy. Who are the people that we're calling assistance eligible individuals, or AEIs. So yet another acronym that we have to learn now. So these folks are employees who lose or had already lost coverage due to involuntary termination of employment or reduction in hours. And I'm going to talk a lot about what that all means in just a second. Keep in mind that this does not have to be related to or caused by the COVID-19 pandemic. So I've gotten a lot of questions recently. We didn't have layoffs due to COVID. Do we have to comply with ARPA? And it really doesn't matter. It really isn't because of COVID. It doesn't have to have happened during COVID. It actually could be all the way back 18 months ago, starting, generally speaking, sometime in mid-October. So the reason I say that is because when somebody is eligible for COBRA for 18 months, when they have a termination of employment or reduction in hours, just in the normal course of business under COBRA. And so this essentially will allow that portion or a portion of somebody's COBRA timeframe to be subsidized if they otherwise meet the criteria to be an assistance eligible individual. So again, this does not have to be related to COVID. It does not have to be during COVID. It doesn't have anything to do with COVID, honestly. So this would also include the family members who lost coverage because of the employee's involuntary termination of employment or any reduction in hours. And I want to take a note and take some time here to talk about what exactly are you talking about when you say involuntary termination of employment. So anything that's not voluntary. So that would be a layoff. That would be somebody who was fired. That would be somebody who, was asked to resign, probably unless they would rather be fired. There's instances where that happens. So this would be somebody who lost their employment involuntarily. It does not include gross misconduct. So under the normal COBRA rules, gross misconduct would take somebody out of being eligible for COBRA altogether. Likewise, it will take them out of being eligible for the subsidy. Now, I want to provide a bit of caution here because gross misconduct is actually not defined under the existing COBRA regulations or the statute. And because of that, it's a little bit problematic in just saying that anybody who kind of left on bad terms has been terminated due to gross misconduct. And when you look back at case law and precedent, because that's really what we have to go off of when we're talking about gross misconduct, you see a theme in looking at all the case law, and there is a lot of case law related to this. So that should tell you that you have to be really careful if you're going to claim somebody was let go due to gross misconduct. Typically, when you see the courts saying that yes, they're confirming that this yes was gross misconduct, is in the event of some sort of criminal behavior, some sort of criminal activity that the person was engaged in. And that could be something like an assault on a coworker, sexual assault. It could be embezzlement of funds from the company. One person asked me if theft from the company would result in gross misconduct, and I said, well, would that mean theft of a stapler or some notepads, or theft of thousands of dollars? Really, I think it's going to be kind of weighed differently depending on the nature of the theft itself. So if you have a situation where you have an employee who you think may have been terminated due to gross misconduct, I would encourage you to get with an employment law attorney and review the facts and circumstances surrounding this employee's behavior and why they were terminated, and documentation that you have before you go ahead and deny somebody COBRA rights and a subsidy because of gross misconduct. I will say that some employees have been able to get away with this if they, prior to the termination, maybe in their handbook or their policies and procedures that are given to the employees, was told beforehand, these these behaviors like violating company policy related to drug testing, this would result in gross misconduct, which means that you would not receive COBRA rights. If you told them that level of detail beforehand and you properly documented that, then maybe in that case, then you would be able to claim gross misconduct. But it's very, very heavily based on the facts and circumstances surrounding the behavior itself and the nature of the termination. So all that to say, be very, very cautious when talking about gross misconduct. So in all other instances, involuntary termination of employment is going to cause somebody to be eligible for the subsidy, as well as any reduction in hours. So reduction in hours does not have to actually be involuntary. And that's interesting because at first we thought that might be an oversight, but now we know that actually in the subsequent guidance that came out just yesterday, so we got a bunch of FAQs and model notices from the Department of Labor that answered a lot of the questions that we had. And we see that reduction in hours absolutely does not have to be involuntary like the termination of employment. And it gives several examples of what exactly a reduction in hours would mean. So that would mean somebody actually choosing to go from full-time to part-time, whether they initiated it or it was some sort of cut in their hours that they didn't want to happen. Either way, that would be a triggering event if that person lost coverage and they still work for you. It would be a temporary leave of absence as long as they still work for you. It could be a downsizing of company operations, and therefore this person, you don't need them to work as many hours. That all would be included in reduction in hours that actually causes a loss of plan eligibility. So that is what would trigger COBRA, and that is what would allow somebody to be an assistance eligible individual. Now, it's not available for other COBRA events such as death, divorce, or loss of dependent eligibility. So if somebody loses coverage due to a divorce or loss of dependent eligibility, which is very common, they are not an assistance eligible individual in that case. Again, it's not available for those who voluntarily terminate employment. So think retirement, I resigned, I quit because I got another job, I asked to leave my job, you know, those types of things where they actually terminate employment voluntarily and are no longer covered under the plan. Those people would not be AEIs. They would not be eligible for any assistance under this law. It's available, meaning the subsidy is available for qualified beneficiaries who are enrolled or became eligible for COBRA on or after April 1st of 2021 and before the subsidy ends, which is September 30th of 2021. So again, through that 6-month period. If the AEI pays their premium by mistake during this period, then the employer, you, must issue a refund within 60 days after that individual elects COBRA. So what this law actually does is it opens up what we would call a special election period. And I want to be really clear on what is happening in this special election period and how this is supposed to work. And we did receive confirmation from the Department of Labor regulations issued yesterday, because typically we get legislation that Congress passes in the form of a bill that becomes law. And then they task the different agencies, Department of Labor, Treasury, and Health and Human Services with writing regulations that go into enforcement activity and just the particulars that it isn't mentioned in the legislation. So that's what we got yesterday. We got several FAQs, about 30 FAQs related to this specific topic, which I have provided a link for in the slides as well. So I would encourage you to go and take a look at the FAQs because they're really easy to read and you can see how this is going to work, but we're going to talk about that today. So the subsidy itself, the subsidized coverage, is available if the qualified beneficiary, and that's just a fancy word for somebody who's eligible for COBRA, if they became eligible before April 1st of 2021, and they're still within their COBRA 18-month maximum period. So that 18 months of COBRA that they get, they're still within that period. And that period happens to overlap with the subsidized period. So that's going to be somebody who's still within 18 months and it just happens to still be in the subsidized period. This is available even if they didn't elect COBRA when they were initially offered it, or if they discontinued it before April 1st, 2021. It gives them a new chance to enroll. So I want to be clear that they don't have to have elected COBRA beforehand. You may have fired them and you didn't hear from them again. You sent them the COBRA notice. This would actually give that person a new chance to enroll, and you would have to provide the subsidy if they are still actually an AEI, assistance eligible individual. Also, if somebody was taking COBRA for maybe a month or 2 months, they stopped paying you, you haven't heard from them again, same thing. This would allow them to come onto your plan as of April 1st and get their payment, their coverage subsidized throughout the duration of their either 18 months of COBRA or until the subsidy ends, whichever happens sooner. So the new election period would be retroactive back to April 1st, and it will last through the end of the normal COBRA maximum period, but the premium subsidy part ends, it goes no longer than September 30th. AEIs can come on COBRA as a 4-1 with a gap in coverage. So I put likely there, but now we don't need any further guidance. We have that guidance. The slide is from yesterday, and now we know. So they can come on to COBRA as a 4-1 with a gap in coverage from months beforehand that they normally would have had to pay for. They don't have to come current, in other words. They don't have to pay you back to be covered from, you know, let's say if I triggered COBRA in December, you didn't hear from me in January, February, or March, but you notified me that I'm an AEI, I could just come on as of April 1st and I would not have to pay back January, February, or March. You don't have to pay for it either. They just wouldn't be covered for that period. Or they can decide to pay you back, get those months covered, meaning they would have any claims incurred that were paid for those months. So either or, they can come current and not have a gap in coverage, or they can come on as of April 1st with the subsidy. You do not have to pay back the premiums prior to April 1st. So I hope that's very clear about how this is going to work. It just gives them a second chance to enroll. So an assistance eligible individual is going to take themselves out of eligibility for a subsidy upon the earlier of these dates here. So first of all, the date that the individual becomes eligible for Medicare or other group health plan coverage. And other group health plan coverage includes a new employer's plan, but it also includes a spouse's plan or a parent's plan. So what that means is if you have a former employee and they've gotten another job by now and they have eligibility for that new plan, even if it isn't as rich as your plan, they cannot receive the subsidy. They could take COBRA, but they would not be eligible to take the subsidy. Same thing with the spouse's plan. If they're eligible for a spouse's group health plan coverage with their spouse's employer or their parent's employer, then they would not be eligible for the subsidy any longer. Also, eligibility for Medicare would take them out of the subsidy. So they could still stay on COBRA, but they would have to pay for it at that point. Also, they would cease to be an AEI after the date following the normal COBRA expiration date. So again, COBRA in this instance runs for 18 months. It does get extended at certain points for disability and things like that, but this subsidy is only going to apply to the 18-month COBRA maximum period triggered because of an involuntary termination of employment or any reduction in hours. And so what this is saying is that if somebody's COBRA maximum period is exhausted during the subsidized period, then that's when the subsidy would end because their COBRA would end. So I think that's pretty clear. So individuals must actually notify the employer if they become eligible for Medicare or other group health plan coverage, or they could face a $250 or more fine. So it's very important. It's very important that you notify these individuals that they might be assistance eligible individuals, and they will have to attest to the fact that they'll have to actually say and have them say in writing, no, I'm not eligible for any other group health plan coverage, including my spouse's. no, I'm not eligible for Medicare. And this is, note the word eligible. It doesn't matter if they're actually enrolled in it. It's eligible for it. So that's really different from how COBRA normally works. So there is a plan enrollment option that an employer can take advantage of if you choose to. So I put here that this is optional, it's totally permissive, you do not have to allow this, but you can, and it might make sense for some of you to allow this in some instances. But what this is saying is that the employer may choose to let the AEI change health plan options from the coverage that was in place when COBRA was triggered to enroll into a lower priced medical plan. Not a higher priced plan, but a lower priced plan, so they can buy down to the lower priced plan option. If you actually want to allow this, again, you don't have to, then they would have to tell you 90 days after the notice of enrollment option that they want to go down to the lower price plan. So you might be saying, well, why would an employee want to move to a lower price plan if we are paying the subsidy for them, or paying for COBRA for them? And in most cases, I think it doesn't really make sense that they would, but if maybe they want to continue on COBRA after the subsidy is over with, after September, then maybe they know, hey, I want to pay less when I have to pay for it myself. Or perhaps they want to preserve HSA eligibility, because if you want to contribute pre-tax to a health savings account, you have to actually be enrolled in a high deductible health plan, and maybe you have that as a lower option. So maybe you have a copay high plan and maybe a high deductible health plan that's the lower price plan, and you could allow them to go down to the high deductible health plan. Not all cases is the high deductible health plan cheaper, but in many instances it is. So these are some things to just think through. If you want to allow it, that's great. If you don't want to, that's great. But if you want to allow it, you need to update your election forms or communicate that to your COBRA vendors that you want to allow these individuals to go down a step with their medical plan option. Okay, so I want to talk about which employers this applies to specifically, and what types of plans does this apply to, because I think there's some confusion here, and I want to just be very clear on who all of this applies to. So first of all, it applies to plans that are subject to COBRA because of ERISA. So if you're, most of you are subject to ERISA. If you're a governmental plan, then you would be exempt from ERISA. But ERISA applies to almost every kind of employer except for very narrow exceptions. Governmental plans, church plans, and Indian tribes. All other employers are subject to ERISA. And if you're subject to ERISA, then if you are large enough, meaning you have more than 20 employees on the previous calendar year, then you would be subject to COBRA under ERISA. If you are a non-ERISA plan, maybe you're a governmental plan, a governmental entity, a public university, city plan, county plan, state plan, non-federal governmental plan, you wouldn't be subject to ERISA, but you would be subject to COBRA by way of the PHSA, the Public Health Service Act. That is why public plans, non-federal governmental plans have to also comply with COBRA, is under the PHSA. Also, any non-COBRA plans, meaning non-COBRA employers, meaning employers that are too small to have to comply with COBRA, you may have to comply instead with state continuation. So many states, almost all states except for a few, have many COBRA laws that apply to typically plans with 1 to 19 total employees. And so if you have a fully insured small plan, maybe you have 5 employees, then this will apply to you by way of state continuation if it applies in the state where you are located. So in other words, this applies to almost every employer. What plans does it actually include? So it includes all group health plan coverage. And under COBRA, group health plan is not just the major medical plan. It definitely includes the major medical plan, but it also includes standalone dental, standalone vision. It includes underspent HRAs. some EAPs, and some on-site clinics if they provide medical care. So most employers at least offer major medical, dental, and vision. And so those plans are going to be included not only under COBRA as usual, but also under the subsidy. It specifically, however, excludes health FSAs. So all other benefits subject to COBRA are included within the subsidy portion. So what does that mean exactly? If you have medical, dental, and vision, and somebody was enrolled in medical, dental, and vision, maybe they had all their family members on all three of them. Maybe some of those are voluntary. Maybe the dental, the vision, they're voluntary plans, meaning active employees pay 100% of their own costs. If they had that coverage in place the day before they had the involuntary termination of employment or reduction in hours that caused a loss of eligibility under that plan, and they're still within their COBRA 18-month maximum period, then you would have to subsidize the coverage for not only just the medical, but the medical, the dental, and vision, and for their family members as well. Even if you don't currently pay the premiums for any family members, or maybe you pay part of it, it doesn't matter. The subsidy has to be paid 100% by the employer, but you will receive dollar for dollar reimbursement through the payroll Medicare taxes. And I'm going to talk about that in just a moment. So there are several notice requirements that are brand new under ARPA. And I will say that most COBRA vendors, most COBRA TPAs are already working on this. They already have notices that they use. They've updated their notices. We have model notices that were just issued from the DOL yesterday. So we know exactly what they're supposed to say. No more wondering. But what do we have to disclose to employees? Well, first we have an election notice for those who became eligible during the premium assistance period to let them know about the availability of the subsidy and the option to enroll in a lower price plan if you want to allow that. Also, those who previously had dropped or waived COBRA must be notified of the new election period and the availability of the premium assistance. So this would be anybody that's still within their 18 months of COBRA that triggered it previously. You have to give that notice by May 31st of 2021. And then the individual has 60 days to actually elect it. They have to tell you that they want to take the coverage. If you don't hear from them after 60 days, then that right for them is lost. Also, a notice must be given to those whose premium assistance is going to end soon. So you have to tell them the date it's going to expire, and this is all contained in the model notices as well. And give it to them no less than 15 days before the subsidy is set to expire. So if they go all the way through the end of the subsidy period to September 30th, then you would need to give it to them in mid-September. If it expires before that because they become eligible for other group health plan coverage or some other Medicare coverage, then you would give it to them prior to them losing the subsidy. And of course, I put here then that the model notices will be issued. Those are out, and so we don't have to wonder any longer. So moving over to the employer tax credits, this is the way that the federal government is going to pay back an employer for providing the subsidy in the first place. So this is actually the part we know the least about at this point. And I will say, though, that the IRS and the Treasury, I just saw a message from the chief counsel that's over the section that deals with employee benefit plans, that they were working feverishly on their regulations and they were going to issue them soon. So we should see IRS and Treasury regulations fairly soon related to how to claim the tax credit and other issues too, because they have a part to play in COBRA. But this in general is how ARPA says it's going to work. So the employer or carrier to which the AEI would have paid their COBRA premium is eligible for a credit against their Medicare payroll taxes. So that 1.45% of payroll that is what is going to be credited and refunded to the employer. The credits will apply to each quarter for amounts that are not paid by these individuals. If that credit exceeds the amount of payroll taxes that are actually due, then the credit is fully refundable by some other manner. They're going to tell us what that is. The credit is claimed by the party to which the premium is due. So the carrier, meaning insurance company, for a fully insured plan that's subject to state continuation. So just for those small employer plans not subject to COBRA, the employer will have to, they will be the party to which the premium is due in all instances for a self-funded plan, but also for a fully insured plan or level funded plan that is subject to COBRA. So pretty much all of their employers, they have to pay it, and then they receive the premium, the tax credit from the federal government. And the plan in the case of a MIWA, multiple employer welfare arrangement. The credit also, it says, may be advanced through the end of the most recent payroll period in the quarter, but all it says is that the IRS will set regulations. So we really don't know how to claim an advanced credit, but apparently that's going to be available. And of course, all of these governmental agencies, namely the IRS, will be distributing forms, instructions, record-keeping requirements related to how to actually claim these credits. So some actions that you can take as it relates to ARPA. So first of all, you have to start identifying those who were on or who are still eligible for COBRA due to involuntary termination of employment or any reduction in hours. So for example, that would be those who were laid off. Again, it doesn't have to be related to COVID, just who were laid off for any reason, who were fired for any reason other than gross misconduct, which we talked about, or had any sort of reduction in hours, but for any reason, even if it was voluntary from them, and who are still within their COBRA maximum period of 18 months. So when you think about that, that could be anyone who had or could have had COBRA as far back as November 2019, or maybe even a portion of October 2019, because if you are a plan that cancels coverage the day that they lose eligibility, then COBRA would start the next day. So maybe, for example, October 15th, then their COBRA could come into the middle of April, meaning their 18 months would extend into the middle of April, and that portion of the subsidy might be refundable to the employer. I don't really know how you would get somebody to pay half of a month of COBRA, but or even a plan to cover half of a month of COBRA, but I don't see anything that says that that's not the case, or it has to be the first of the month type of plan. So I'm not sure exactly how that's going to work, but it could be as far back as maybe like mid-October. But for sure, November 2019, you're going to have to look at reports and identify, okay, who was involuntarily terminated, or who had a reduction in hours. You're going to have to let your COBRA vendor know that. If you self-administer COBRA, then you're going to have to identify those individuals and send them a notification that, yes, we believe you're an AEI, and here's your election notice. Send it back to us. Tell us if you're eligible for other group health plan coverage or Medicare, and you can say that there's a penalty for being dishonest about that, not truthful about that. And so this is what you're going to want to do just as soon as possible. So make plans to notify these AEIs, whether it's you, if you self-administer, or the COBRA administrator, and those model notices are available right now. So modify any automatic COBRA termination processes when premiums aren't received from the AEIs. We don't want to be canceling anybody because they didn't pay, because you're going to be paying it. Also, self-administered employers, you may want to consider start using a COBRA vendor, and especially when I get into the outbreak period rules, this may be a very good time for you to get some quotes from COBRA vendors and see if that is something that you want to outsource, because they do a fantastic job of helping you keep track of all of this, and records and mailings, and it's just a lot to keep up with. And also decide if the employer will allow the individuals to enroll in a less expensive medical plan. Again, that's optional. You don't have to allow that, but if you want to, you're going to want to put that in your election packet. And so jumping over to the dependent care changes under ARPA, I just want to take a minute to note this because I think it's interesting, because a lot of you probably do sponsor dependent care FSAs, which allow people to set aside pre-tax money to pay for daycare expenses so that they can be gainfully employed. So just for the 2020 tax year, you can increase that withholding amount from $5,000 up to $10,500 for individual married filing jointly. The plan can be amended retroactively back to, say, January 1st, 2021, as long as that amendment is adopted before the last day of the 2021 plan year. So that would in all likelihood be December 31st of this year. Now, just keep in mind that discrimination testing for dependent care FSAs is already really difficult to pass because of the nature of the testing, because it really looks at who is utilizing the benefit and are those people that are using it, are they highly comped? In most cases, highly comped people tend to use the dependent care benefit because they have the extra money to set aside to pay pre-tax daycare costs. So if you have more people that are highly compensated, already kind of utilizing the benefit, and you increase it even further, that could make it even harder to pass non-discrimination testing based on the way that these tests work. So just kind of think through those things before going ahead and basically doubling the amount that they can withhold from their paychecks each month. Now, I want to touch on the COBRA and HIPAA outbreak period guidance, because this is very, very important. It's pretty confusing, but I have a bunch of examples to show you. And I also want to kind of go through how this might interact with the ARPA subsidies. And so give you some things to think about so that you can plan accordingly. So last year, the Department of Labor issued some regulations that were intended to give people extra time to elect COBRA, to notify individuals of COBRA, and to pay for COBRA. And so what was meant to be, I guess, sort of helpful to the individual is just kind of a nightmare for an employer to have to keep up with all of it. But nevertheless, we went whole year and we did not have an end to the outbreak period, because obviously we are still within the national emergency period. And so the Department of Labor came out pretty recently with regulations on how to proceed with these paused extended timelines after we've gone a full year without an end to the outbreak period. And so what we're gonna have to do is look at an employee and see how this will apply to them on an individual by individual basis. So I have several examples to show you what this means, but basically individuals and plans with the timeframes that are subject to this relief will have those periods paused or disregarded or suspended until the earlier of 1 year from the date in which they were first eligible for this relief from this timeline, or until the end of the outbreak period, whichever happens sooner. So these are the specific timelines that have to be paused under this rule. And again, this has been on for about a year now already, so hopefully you know somewhat of what I'm talking about, because this is not exactly new, but it still is confusing. So let's review this together. So essentially what this means, dates that must be paused from either 1 year from when the relief for these dates first applied, or after the outbreak period, applies to the 60-day election period for electing COBRA. The date for making COBRA premium payments, 30 days ongoing, 45 days for that initial payment. We're just talking about just kind of normal COBRA when you pay for it and you take it and all of that. We're not even really talking about the ARPA subsidies here. So also the date for individuals to notify the plan of any kind of qualifying triggering event or determination of disability. So qualifying events that they would have to notify you about typically include divorce or legal separation, sometimes the dependent aging off the plan. Those would trigger COBRA, but this would allow extra time for those individuals to actually notify you about disability determinations, divorces, and so forth, things that you would not know unless they told you. And so essentially these periods that you see before you, they must be paused for the duration of the outbreak period or 1 year, whichever ends sooner. So let's look at some examples together. So I think this will really help you understand how this is going to work. So a qualified beneficiary whose COBRA election period began last January would be required to make a COBRA election by March 1st, 2020. However, because of the suspended period, it could only last 1 year. This individual had until February 28th, just a few weeks ago, to actually elect COBRA. So you can see here that they had their 60 days, that was paused for the full duration of the year, and then the year was up and they were, they ran out of time to elect COBRA from that point. Now, I will say in this instance that this person, if they were involuntarily terminated and lost coverage because of it, then even though they never elected COBRA, they would definitely be allowed to come on to your plan as of April 1st and have their COBRA coverage subsidized. So in that case, that would be how that would work. So next example, a qualified beneficiary whose COBRA election period began May 1st, 2020 would have normally been required to make a COBRA election by June 30th of 2020. However, due to the disregarded, paused, told period, whatever word you want to use, this individual now has until the end of the outbreak period or until June 29th of 2021, whichever is earlier, to make their COBRA election. So you can see here that the full year goes by and then it is unpaused and then the timelines start up again. Next two examples. An employee is termed from employment in May of 2021 and her COBRA election period would start on June 1st, 2021. She has until July 31st, 2022 to elect COBRA and 45 days after she elects COBRA to make her first premium payment, unless, of course, the outbreak period ends sooner. So her maximum COBRA period stays the same. It would still end 18 months later as of November 30th. It doesn't extend it. It just allows extra time for somebody to elect and pay for COBRA. Next example, an employee is termed May of 2020. He timely elects COBRA and makes the first 3 payments for June, July, and August. He stops paying after August. He is relieved of making payments until the end of the outbreak period or September 2021. He would be required to pay premiums by September 30th, 2021, which is 12 months, and then plus the 30-day grace period after that. So you can see that the full period goes by and then the grace period applies. Now in this instance, they would have to pay back all of those premiums in order to have those months actually covered, meaning their claims, that any claims that were incurred, they would have to pay for the months in order to get those claims paid. But again, in this example, if this person was terminated involuntarily, then they may be eligible for a subsidy for at least the portion that's related to the subsidy. So again, April 1st through September 30th. So you can see here that part of his months would have to be paid back. But again, under ARPA, they really can have a gap in coverage. So hopefully this is kind of thinking in how this is all going to work. Last two examples here, and then we'll take questions. So a qualified beneficiary whose COBRA election period began February 15th would have their COBRA election period disregarded on March 1st, because March 1st was the first day of the outbreak period. It's the first day the president said we're in a national emergency, in other words. The disregarded pause period would last through February 28th, and then they would receive the balance of their 60-day election period, so about 45 days. So you can see here that their election period the clock started to tick. March 1st, oh, we're in the outbreak period, a full year went by, no end to the outbreak period, and so they got the balance of their days once that clock started up again. If they didn't elect COBRA by then they would not be able to elect it. However, if this person was involuntarily terminated, then they might be able to take COBRA as a 4-1 and get their coverage subsidized. Last example includes a very common event for birth of a baby. So I mentioned this, that the COBRA periods were the COBRA timelines were paused, but also special enrollment rights are also paused. So when we think about special enrollments, we're talking about birth of a child, marriage, adoption, placement for adoption, or somebody, the employee, spouse, or child losing other health plan coverage. That would allow them to specially enroll. They would be able to enroll on your plan without having to wait until open enrollment. So it's kind of like their qualifying life event to come on the plan. So what this does is it also extends the time that they have to actually notify you of the special enrollment. So here we see a very common occurrence of a baby being born. The baby was born August 20th last year. The plan normally allows 30 days from the date of the birth for the employee to request a HIPAA special enrollment. The suspended period would last until the earlier of the end of the outbreak period, or August 19th, and then the 30-day special enrollment election period will begin. So in other words, then they have the 30 days after the full year's gone by to say, oh yeah, I forgot to tell you that we had a baby. Baby was born on August 20th, and you would have to actually enroll this baby now. Normally, no, you would say, sorry, too much time has gone by. You'll have to wait till open enrollment. But under this, it just gives them extra time to notify you. So some actions that you can take, whether you are self-administered or you use a COBRA TPA. So for the outbreak period rules that I just talked about, the paused timelines, the language in the Department of Labor's notice says that it strongly recommends sending a modified notice to inform all participants of these suspended timelines. So it's not expressly required for this purpose, but most COBRA vendors have been sending these for a year now with every single COBRA notification that normally goes out. If you're not sending these currently, then we have sample notices that you can choose from. We've been sending these out for many months as well, but if you don't have one, just let us know. And consider sending the notice to all plan participants, not just those on COBRA, because remember, I talked about special enrollment rights, which applies to not just COBRA individuals, but also active employees. Also, to COBRA qualified beneficiaries, for any type of COBRA notice, we always would recommend sending it first-class mail, not certified mail where you have to get a read receipt, but first-class mail is the tried and true way to really be able to show a court or an investigator, DOL investigator or regulator, that you actually distributed the COBRA notice in a manner that was, believed to result in receipt of it, is what I'm trying to say. So even if you can't prove that they opened it or they got it or you got something back in the mail, if you send it first-class mail, then over and over again, the courts have said that that constitutes a proper delivery as long as you send it on time. So we would say to do this instead of sending it via email or giving it some kind of paper packet. First-class mail, especially with COBRA notifications, is the way to do it, and to really prevent any lawsuit or any further complaints, because you can demonstrate, yeah, I notified them and we sent it first-class mail. So discuss that with your COBRA vendors, or if you're not doing that currently self-administered, you may want to consider sending it first-class mail. And discuss with your COBRA administrator to clarify what they are doing and what help they need from you. Because a lot of times the employer has to provide some information to the employee and to the COBRA vendor to be able to properly administer COBRA, especially with ARPA. Because remember, you're going to have to identify who was involuntarily terminated, because COBRA vendors typically don't have that information. So hopefully you'll be able to get with them and have a conference call with them and just go over what exactly they need from you to be able to properly distribute those ARPA election notices, as well as the outbreak period guidance. Make sure that they're on top of that and they're helping you with that. And so most COBRA vendors are very prepared to assist with recent changes, and just contact your representative for assistance. So at this point, we have about 10 minutes, 11 minutes, and here's the credits for CE, SHRM, and HRCI if you would like to submit this for credit. But we have about 11 minutes for questions. So Cassie, if you want to read those out to me, I'll be happy to take some questions.
Yep, please put your questions in the question feature, and I'm just going to take them as they come in. So the first one is, in your last example, such as a baby's birth, If an employee had single medical coverage, hadn't notified us of the birth, once they notify us, let's say September 1st, 2021, then we would retro enroll the child in medical insurance. And are we then allowed to retro collect medical premiums for the difference between single coverage and the employee plus one coverage that they are now requesting?
Yeah, this is a good question, because in the very limited circumstance of a birth of a child, this is the only reason that you should ever be retroactively adding coverage back to the date of the birth. So in all other instances with HIPAA special enrollment rights, it should be prospective. So let's say there was a marriage, you would add them prospectively, meaning probably the first of the next month when they finally told you about it. But in the case of a birth, you would likely, if the employee wants you to add them back all the way for those months previous. And yes, they would have to pay for it. So you'd have to figure out a way to collect premiums, which could be, you know, a little bit tricky with so many months going by. But if they want to go all the way back, then they have that right under the HIPAA special enrollment right rules. Good question.
Thanks, Sarah. The next one is, for a teacher who resigns instead of being non-renewed, that would be an involuntary termination. Is that specified in the law, or is that just a frequently asked question?
So this is not discussed in any of the regulations or legislation yet. Hopefully it will be some of these kind of weird different situations, like not renewing contracts for employment. And I would tend to say that while it's not clear, that the terms of the contract were known in advance, and perhaps that isn't an involuntary termination. It was just that the contract expired. So it's not clear, but I think you would really need to look on the facts and circumstances surrounding this. Is sort of, was it expected, or was, you know, were they expected to end the contract or not? So I wish I could give you a more clear answer, but at this point we just don't really know exactly how that would work.
All right, the next question is, for the outbreak period, does that apply to all COBRA eligible individuals, even those who had voluntary termination?
Yes, so the outbreak period rules apply to anybody who is eligible for COBRA for any triggering event. So they're really separate and apart from the ARPA rules, where I talked about involuntary termination of employment. Yes.
All right, next question is, if you have an attendance policy with a point system and an employee points out, is this an involuntary or voluntary termination?
I would say that's probably an involuntary situation, because again, you let them go because of, you know, some sort of performance issue, attendance issue. Sounds like it, but again, it's not defined under the regulations or the legislation. It just says involuntary. It doesn't give any examples. It does for reduction in hours, but not for involuntary termination of employment.
Thank you. And next question, for state continuation, the employee may still be eligible for the subsidized COBRA. Will the employer get federal Medicare credit for state continuation?
So in the case of state continuation, the carrier is actually supposed to pay it and receive the credit from the federal government, although that's not exactly clear, and the carriers don't seem to know how they're going to comply with that either. So with yesterday's regulations and also in the ARPA law, it talks a lot about the carrier having to pay for that. So in the instance of state continuation fully insured plan, the carrier is the one who's supposed to pay it and receive the credit from the federal government, not the employer.
Thank you. The next question is, of the notices released, what is the alternative notice used for? The general notice and extended election period notice makes sense, but I'm not sure what to do about the alternative notice.
So in the new model notices, this could be, you could use this notification, and if I'm remembering which one you're talking about, there is one that you could use to, I believe, ask them if they were eligible for the other coverage. I can't exactly remember, but I think that I'll have to give you the answer on that. So let me look closer at it because I just can't remember exactly what it says at this point since it's so new.
No problem, thank you. The next question is, who is policing the $250 fine if AEIs become eligible for other group coverage, but they do not indicate that to the employer or the COBRA TPA?
So that is assessed by the Department of Labor. I don't exactly know how you would get them to assess that fee or that penalty, but perhaps if that were the case where somebody was dishonest, then you could report them to the Department of Labor, but it's not exactly clear how that would be enforced. But I think it's a good idea to have that on your notifications because it is pretty scary for somebody to read that and may cause them to actually answer the question truthfully.
Here's another question about AEIs. I see that an AEI can sign up for COBRA starting 4/1 even if they did not sign up earlier. If they do, can the AEI drop after 9/30 and sign up after and pay back the months after September?
Yes, so they can either choose to drop COBRA at that point and do something else, or they can continue as long as they're still within their 18-month maximum period, and they could pay for any months prior or after September 30th, or they also could choose to pay back, in all likelihood, they could choose to pay back any premiums prior to April 1st, like March, February, those, so that they wouldn't have a gap in coverage. Yes.
Thank you. Next question is, what if your yearly Medicare doesn't come close to covering the credits you should receive for covering COBRA? How long do we have to use that credit?
So can you repeat that? I don't know if I
Yes.
understood that question.
So what if your yearly Medicare doesn't cover the credits you should receive for covering COBRA?
Okay, so the Medicare payroll taxes, that's right. So it clearly says that if your subsidy amount, the amount that you've been paying for these individuals, exceeds the amount that you would be receiving back in the form of a tax credit for the Medicare payroll taxes, then anything above that would be fully refundable by the federal government. Again, we don't exactly know how, but if there's some other way that they're going to pay you back for the rest of the amount.
Thank you. If someone elects coverage a year later under the outbreak period, can they choose the effective date, or is it an automatic retro to the date they were first eligible?
So under the outbreak period guidance, they cannot choose their effective date. They would have to, under that guidance, come current from when they had last paid or from when their COBRA start date was. So for example, I could not say, oh, I triggered COBRA April 1st last year, and so therefore I want my COBRA to start December, and I'm only going to pay back to December. It doesn't work that way. You'd have to go all the way back to April 1st if you wanted to have any COBRA at all.
Thank you. And Sarah, this question might lead into you providing some information on what we'll be giving to the attendees after this. Can you provide the link to the updated information that came out yesterday and or where to look on the Department of Labor website?
Absolutely will. There's a nice page where the FAQs are located and the model notices. So I will include that in the slides. I, for some reason, don't have a link in my slides, but I'll add that to the slide deck.
Thank you. Next question is, I heard that there is discussion already of the COBRA subsidy extending beyond 9/30/2021. Do you find any truth in that?
I've been asked this a lot, and I think it's possible, but it would have to be done literally by an act of Congress. And so in order to get the legislation passed, obviously you have to have both chambers. So you have to have the Senate and the House to pass a bill, and both parties within each chamber have to agree on it. So it could, I'm not even sure how they get anything passed that way, but truthfully, it might be extended beyond that. But we had a similar situation back with the 2008 financial crisis, in 2008 with the ARPA COBRA subsidies, which was kind of similar to this, and that was temporary. So hopefully this will be temporary as well and not extend, but they could choose to do that, but it would have to be through legislative action.
Thank you. We've got a question kind of asking about a specific scenario for you to clarify. We have seasonal employees who were offered and did not accept COBRA in November of 2020. Anticipating that they are returning in May 2021, do we have to offer them subsidized COBRA for the month of April? Can you further clarify if returning employees cannot then choose to stay on subsidized COBRA instead of enrolling back into the group plan?
Okay, so if the individuals were seasonal and they lost their coverage, meaning they were terminated involuntarily, their employment was terminated involuntarily, or they had any reduction in hours, then they would be AEIs. And so in the case of a seasonal employee who might come back a year later, but they've actually terminated employment, meaning they're not your employees anymore. They're not on some kind of leave or something like that, which I don't think would be the case. And perhaps they were offered COBRA, then they didn't take it. In all likelihood, they would have been involuntarily terminated, and they would be AEIs. If you're going to rehire them at some point, then that would take them out of the subsidy because it's other group health plan coverage technically then. So yes, that would be the scenario I would envision.
And perfect timing, Sarah. We've just come up on 2 o'clock. Thank you all so much for your questions, for your participation. We'd love for you to fill out the survey to let us know more about what you thought about this webinar. And again, a big thanks to Sarah for providing her expertise for us. And I hope everyone has a wonderful rest of their afternoon. Thank you for joining.
Thanks, everybody.